Welcome to our lecture on conspiracy under Ghanaian law. Today, we'll explore what makes conspiracy a unique Inchoate offense, how the law has evolved, and the specific rules that govern when an agreement crosses the line into criminal liability. Conspiracy is an Inchoate offense, meaning it's a criminal act that falls short of a completed crime. The offense is actually committed the very moment two or more people agree to commit or abet a crime, regardless of whether they follow through. Conspiracies can take complex forms. In a wheel conspiracy, a single ringleader, the hub, recruits multiple unconnected people, the spokes. In a chain conspiracy, individuals are linked sequentially, like a supply chain for illegal drugs. Both structures impose liability on all involved. The statutory definition in Ghana has seen a crucial amendment. Under the old law, you could be guilty if you agreed or acted together with someone. The new law, affirmed in cases like Kwebu versus Attorney General, strictly requires a prior agreement to act together. This shift from or to to is massive. It means you can no longer be guilty of conspiracy simply by acting along someone without a prior agreement. The prosecution must prove that a meeting of the minds happened first. Let's break down the elements. Having dark thoughts isn't a crime. The actus reus, or guilty act, of conspiracy is the agreement itself. As established in R versus Aspinall, the crime is complete the moment the agreement is made, even if they later repent. The mens rea, or guilty mind, is the specific intention to commit or abet that same crime. If two people agree to hire a hitman, their shared intention to procure that murder satisfies the mental element of the conspiracy. How is this punished? Under Section 24 of Act 29, if the conspirators actually succeed in committing the crime, they are punished for that specific crime. If they fail or are stopped, they are punished as if they had abetted it. Now for the applicable rules. First, you need at least two human beings. In the fascinating case of Blay versus the Republic, a conviction was quashed because the accused supposedly conspired with a spirit. The court clarified that you cannot conspire with ghosts, animals, or yourself. Next, if three people are charged and two are acquitted, the third must also be acquitted because they couldn't have conspired alone. Furthermore, if you agree with an undercover cop who is just pretending, like in State versus Pacheco, there is no genuine bilateral agreement. Since criminals rarely record their agreements, direct evidence is scarce. Courts often rely on circumstantial evidence. If parties act in a highly coordinated way later on, courts can infer a prior agreement existed, as seen in cases like Azametsi, where presence and coordination implied a common purpose. It is vital to distinguish between negotiating and actually agreeing. If you sit in on a discussion about a potential crime, but leave before any final plan is cemented, you are not guilty of conspiracy. The law requires a finalized agreement, not just brainstorming. Finally, when relying on circumstantial evidence, the inference of conspiracy must be the only logical conclusion. In Larte versus the Republic, a discrepancy in loaded goods could have been a simple counting mistake. If a coincidence is plausible, the conspiracy charge must fail. To wrap up, conspiracy in Ghana is an inchoate offense centered entirely on the act of agreeing to commit a crime. Remember, the new law requires proof of a prior agreement, and there must be a genuine meeting of at least two human minds.